Do sit down, everyone, other than counsel who's about to address us. Yes.
Good morning, my lords and my lady. If I may start with just a couple of housekeeping matters before getting into the substance of things, and unless, my lord, there's anything you wish to raise by way of...
The only thing I'll say by way of preliminary, I'm sure everybody professionally involved with the case is aware of this, but the identity of the boy and his family is protected by an anonymity order, as was below. There's no confidentiality about the fact that the local authority appellant is Hampshire, but the identity of the individual family is not to be disclosed.
Yes, that is understood.
Yes.
There has, in keeping with that anonymity previously, and if it's necessary to refer to the child at all, the initial T has been used.
Yes.
And that is what we will endeavour
that's
to do. Thank you for that, my lord. On practicalities, and firstly, may I introduce Miss Buffet, who
Yes.
Assists me. Mr. Gilly represents the parents, and he's assisted by Miss Swords-Keeley. In terms of the documents, my lord, you and your lordships and ladyship will have received a core bundle, an authorities bundle. We apologise for the relatively late addition to the authorities bundle, which is in regard to the belonging regulations, and you should have received an update to that. Your lordships and ladyship hasn't. We can address that.
Not.
Where will they be?
Not sure about that.
So within the authorities bundle, you have at tab, if you are tabbed, 5, but if not at...
We're tabbed, but the index doesn't say which tab, so you can make an intelligent guess. Page 45 is the belonging regulations?
Yeah, so those were the original regulations, which I noticed had been included by accident, and we subsequently provided the amended versions, and those were paginated at page 682 through to 688, and that was merely because of ease in including it within the already...
I'm afraid not. I don't know whose fault that is.
Well, we take responsibility for that entirely.
So 682 to 688?
Yes.
Education areas to which pupils and students belong, regulations 1996?
Correct, my lord.
So I have it in the electronic.
You have it. Excellent. So it will be at the back of the authorities bundle. We appreciate that's not ideal. Really, the material...
Well, never mind that, but if we're going to look at them, certainly I...
Yeah, I've got page 682, but not up to 688.
Okay, well, if a couple of copies could be rustled up at some point.
Can you see that?
There's one here.
Yes, of course.
There is one additional document which I wish to put before the court, which is a single page, an extract from the explanatory notes from the Children and Families Act, which I noticed recently. I've provided a copy to Mr. Gilly. I understand that no objection is taken, so with your permission, my lord, I wish to hand that up, and again I offer my apologies.
Sorry, what's this? It's one copy.
This is a replacement bundle.
Is that aimed to be...
This is a spare replacement authorities bundle which does have the correct version of belonging regulations at the back. So it would just be the back of the second of those two bundles. That's the full authorities bundle.
It may be that it would assist to take out the relevant pages so those can be inserted into their lordships and ladyships bundle.
Yeah, that one stops where mine stops.
Oh.
Sorry, could you just repeat again what pages? This bundle also stops at 682.
Yes, so the original end point of the bundle will be page 681. The insertion should add 682 to 688.
Right.
Go back to
Slightly eccentrically. They're all numbered 682, but it is a set of regulations.
Well, it appears that you have that, and I don't know why
Don't worry about
that
it. We'll work
copy
out.
has made its way to your lordships and ladyship, and I apologise for it.
Yes.
But the main thing is that it appears that you have the correct version of regulations.
Right.
Send a photocopy.
Yeah.
Well, whilst that perhaps...
Right. Can I?
Yeah.
This is several hundred pages of stuff, but Miss Buffet can have it back. Right. Thank you.
I apologise for that, although I'm glad to raise it now and get it out
Yes.
of the way with, rather than create this sort of confusion in the midst of submissions. So those were the only housekeeping points that I wished to raise. Unless there's anything else, I intend to proceed with the grounds. And I intend to address them in the order in which they appear in the skeleton argument and the written grounds document. So starting with the first one, which goes to essentially the jurisdiction of the First-tier Tribunal, and whether, so the extent to which it may take into account procedural impropriety in the context of a statutory appeal. If I may start by taking your lordships and ladyships of a decision of Judge West to identify the relevant aspects of that decision, and it should start at page 126 of your core bundle. And in particular, 160 at the bottom, where Regulation 31 of the 2014 Special Educational Needs and Disability Regulations is set out, described as clearly mandatory. We don't dispute that it's mandatory in its language. And over the page to paragraph 161, where Mr. Gilly's submissions below were accepted as to the mandatory nature of the obligations and also the consequences of the failure to comply with them. And then at 162, which is the key passage, where Judge West concludes that a cease to maintain decision will be invalid if it's taken in breach of those mandatory requirements, and he leaves open for another case whether the facts are different as to whether that could result in a different outcome. He then at 163 quotes and endorses the findings of the tribunal below. So we say what he has done here is reach a conclusion that a mere fact of a breach of a mandatory requirement in a regulation in and of itself and without more means that an appeal before the First-tier Tribunal can be upheld. I also refer your lordships and ladyship to paragraph 231 of his decision, which is at page 159, where he is discussing the tribunal's decision below and comments on the contrary. The short point was that if a case fails on a preliminary point in any event, as the tribunal decided, there is no need to have to go on to consider the substantive merits.
So sorry, Mr. Lyme, which
Yeah.
paragraph?
Paragraph 231 on page, my lord, 159.
Yes.
Grateful. So this is relevant in terms of the insight and the endorsement given to the tribunal's decision, which was to decide this on a straightforward preliminary issue, effectively, as to procedural breach, without engaging with the merits of the case before it, which, in a case of this nature, under section 45(1)(a), was a question of whether the child was in the area of the local authority. So what has happened here is the tribunal has not gone into the merits of that decision on the basis that preliminarily there was a failure to consult, and that in and of itself determined the appeal. And our reading of Judge West's decision is to say that that is an approach which the tribunal may take.
Although he didn't take it himself.
No, he didn't.
He went on to consider the merits in great detail.
Judge West clearly did, because of the way that the appeal developed, but he does make a very clear decision, and I refer back
Yes.
to the previous paragraphs we looked to, as to the invalidation of the decision. So, in summary, our position is that in relation to consideration of past procedural breaches which arise prior to a decision which is then appealed, those, we say, are principally just that, matters of background for the tribunal in a statutory appeal context. We respectfully say that they should not be used to determine the appeal on its merits, but certainly what the tribunal can't do is ignore the merits of the decision that is before it. If the tribunal, if the court is against me on that, and the court is, as a matter of principle and jurisdiction, entitled to take into account those matters, then we say it has to approach that question in the right way, and we say that here the First-tier Tribunal and Upper Tribunal were wrong to conclude that a decision is invalidated simply because of a procedural breach, and we say that the approach to take to that question is premised on the case of Synergy, which I'll come to later, in relation to which one has to look at what is the intended consequence of the breach in the statutory scheme, and we say neither the First-tier Tribunal nor the Upper Tribunal approached this question in that way in this case.
Well, before we get to that,
Yes, my lord.
what is the purpose of these procedural requirements?
I failed to hear the final word.
What is the purpose of these procedural requirements?
Yes, well, the purpose of the procedural requirement clearly section 19, and this is a matter which your lordship looked at in the Milburn case of the Children and Families Act, generally applies to all decision making within part 3, and we accept that the views of the child, young person and or their parents are things which have to be taken into account by
And the headmaster.
uh,
And the headmaster.
well, in the case where the child is attendant at a school, then that would be obviously right.
And why?
Well, the purpose is to take them into account, and of course, that in taking it into account, that is something which can be relevant to decision making, but does not, in my submission, determine the outcome. So, at most, in the context of a consultation, we say it's something of importance, but it doesn't direct the decision which a local authority has to ultimately
But
make.
it must be highly relevant to the making of any decision.
In a case concerning the meeting of needs of a child or young person with SEN, then, of course, taking those matters into account is of relevance. And we don't shy away from the fact that they are very important matters. Nevertheless, there isn't always going to be symmetry between what a parent or a young person or a child wants and what a local authority has to provide.
Well, that no doubt is why the school has to be consulted.
Well, again,
because inevitably any parent is going to have a more subjective view of their child than the school is.
again, those are relevant considerations, and in a public law context, and we appreciate we're in a species of that within the tribunal, but these are matters which the legislation says are to be taken into account. Where I divert from this, from the respondents, is to say, or at least I think I do, is to say that yes, these are to be taken into account, but they are not determinative of the outcome. It doesn't follow that because they are taken into account that a decision that is made by a local authority has to correspond with what is
No, of course
said.
not. No,
in the
no,
consultation.
That I would expect to be common ground. But
Yes.
the flip side is what matters, which is if you have a procedural irregularity on something which goes right to the heart of what plan should be made, then we get on to the question, which is your Sonergy question,
Yes.
of what is the remedy for this breach of this mandatory and important requirement.
Yes.
And I suppose you could say, well, it may depend upon the extent of the breach, but we're dealing with things that have rightly been described as egregious breaches here.
Well, actually, I don't look at it from the perspective of extent of the breach primarily, because what I say is that one looks at the statutory scheme, and if the scheme demonstrates an intention by Parliament that a breach, whether it's minor in nature or egregious, in relation to which opinions can differ, but I accept what has been found in this case, if the scheme properly interpreted suggests that Parliament didn't intend there to be invalidation, then that is the answer. And I submit that in this case, the answer is clear, that when one looks, and I can take you to the relevant provisions, and perhaps that is a helpful starting point, but when one looks at the machinery that is in place here, I don't shy away from the importance of consultation. That is not something I wish to undermine in my submissions, but I submit that that is only the first question, and one has to look at the scheme in operation, and if the answer based on that is that invalidation is not intended, then it's wrong to reach a conclusion based on the mere fact of a breach that a decision of that nature is invalidated. It is the wrong way to look at it in my respectful submission. If I could ask your lordships and ladyship to bring up, if I may, the relevant statutory provisions. The first is
You've referred in your grounds of appeal and also in your
yes.
skeleton argument to some of them.
Yes.
If you're just going to refer to those, then that might be the best source.
Yes. I certainly can. So, within the skeleton argument, which you will have in the core bundle, relevant starting point is at page 230. Paragraph 14. So this is the cease to maintain entry point, the provision which gives the local authority discretion to cease to maintain, one of the grounds being, as in this case, that the authority is no longer in the the child or young person is no longer in the authority's area by reason of not being responsible. We say responsible as a
as you say in the footnote, it has
Yes.
to be read together.
Yes.
Maybe the previous page is the place to start.
My apologies. You're quite right, my lord, and I'm grateful for that. But in actual fact, I don't wish to get into the responsibility question too much at this stage, because that will come in ground two. I apologise for any confusion that may have been generated there. And then section 45.4 at paragraph 15, which I don't quote from directly, but I summarise, says that local authority may not cease to maintain an EHC plan for a child or young person until after the period of bringing an appeal has expired, or where it is made until after that appeal has been finally determined. So the operation of that is that where an appeal is made, the cease to maintain decision is stayed. It can't be effected until such point that the tribunal, standing in its shoes, has looked at that decision, either approved it or remade it. And so, turning over the page in my skeleton argument to paragraph 16, there are regulations, which I've referred to already, made under section 45, and that is where we see the consultation requirements that we've already referred to. And admittedly, and obviously, they include, amongst other things, the consultation duty. And then over the page, again, my lords and lady, right of appeal, paragraph 20 and 21, where I summarise the position that there is a right of appeal, which obviously follows, against the decision under section 45. So, looked in context, and sort of taking things in reverse in a way, but look at, to answer my lord's sort of question about how this operates, we say that effectively puts things on ice, and it can't be the intention for total invalidity to follow where there's been a breach of a consultation requirement, when there is in effect no prejudice to the individual concerned in the immediate...
How do you know there's no prejudice to the individual concerned if you don't consult?
Well, because the prejudice to an individual in a cease to maintain context would be that the plan ceased to exist, and so therefore...
That's pretty prejudicial if you happen to be the child.
Highly prejudicial, but my point... I agree, but my point is that...
Sorry, it's just you said there was no prejudice, so I couldn't see how that worked.
Because that decision isn't implemented. The nature of how these...
No, but you're going to make the decision absent consultation.
Yes,
so the fact that it's maintained doesn't help, does it? Because it's just bubbling along on the old scheme. But then no consultation takes place prior to deciding to bring it to an end.
In my submission, there would be obvious prejudice if that resulted in the actual cessation of the plan. I would have to accept that. Yeah. But in a situation where actually that doesn't happen, because the consequence of the appeal is that the local authority can't implement that decision, but instead has to carry on maintaining that plan in the form that existed prior to its decision.
But it's not just a binary question of whether there's a plan or not.
Yes.
The failure to consult may affect the specified terms of the provision that's going to be... Sorry, I'm getting in a muddle. The specified services that are going to be provided under the plan. And the problem with a procedural error is you can't actually do an action replay, and you except, you would say, by an appeal. But the vice of a procedural requirement such as this is you don't know what effect it has had.
In my submission, there are nuances to that, because there are of course two grounds under section 45 for ceasing to maintain a plan. One of which is the responsibility question. The other is it necessary to continue maintaining the plan? Now, in this case, we're dealing with the first of those. Your Lordship might well be right, dependent on the circumstances, where if a decision is that a plan is not necessary, then a question arises which is then dealt with at the tribunal. Is it necessary to maintain the plan? And questions around what should be within it could arise, although functionally the main purpose of the consultation in this context is to decide whether to end the plan at that point or not. If the question is purely, is the child in the area, therefore does the local authority have responsibility for it, which is this case, then in my respectful submission, it's difficult to see that question arising in quite the same way.
Sorry,
Yes, my lady.
Sorry to interrupt you, but just so I'm clear, so is your submission that the importance or otherwise of procedural irregularities will be different if we're looking at 45.1a from if we're looking at 45.1b? Surely that can't be.
No, I'm accepting, as I have originally, that consultation is a matter that is within the statutory scheme has importance.
No, it's just when you were saying that responsible A will be different from B.
Well, I'm suggesting that it could be different, because I think the original question, as I understood it, would be that within the context of a consultation, one question that might arise would be what provision should be made for the child in question. If the main reason, or the only reason, is for ceasing to maintain a plan is that the child is no longer in the area of the local authority, then in my submission, that isn't the discussion that's being had in this type of case. It's a question of whether the individual is present or not. And so that's, I'm not suggesting that the matters that your lordships state could never arise, but there will, the nuances are there, and I don't respectfully accept that they will always arise in a very in the way that is suggested.
Thank you. Sorry, I interrupted you.
My lady, not at all, not at all. I was expecting, of course, interventions of many.
Came to the right place.
Yes. I'm grateful nonetheless. So I've taken your lordships and ladyships through. I mean, that serves as a, if you like, a preliminary to my ultimate point here, which is, as I say, that
Rounds 2 and 3.
Well, I was hoping it served as an endpoint to ground one. I'm afraid there is more to go with.
Well, there is more,
No.
to go. I mean, you're saying on ground one, you not only attack the FTT's approach endorsed by Judge West, that failure to consult in breach of Regulation 31 renders the decision invalid, but you also say that it's no business of the tribunal anyway, that the aggrieved party has first to go to the administrative court, get permission, get the decision quashed, and then a few months or years down the line, only then go to the tribunal.
Well, I do say that as my starting position, and I don't say, and what I'm not saying is that a tribunal can never, looking at an appeal before it's in the round, consider what has happened in the build-up, and I do accept that there may be practicalities that impact on a tribunal's jurisdiction caused by a failure to consult. And an example might well be if evidence or matters could have been addressed or dealt with on the consultation, that might restrict what you could imagine in the context of an application for late evidence, the scope by which a local authority is able to put evidence before the tribunal. But the reason I make this point is I submit that looking at the historic authorities on the nature and scope of the tribunal's jurisdiction, yes, it has a broad jurisdiction, and yes, there's flexibility in it, but the clear thrust of what comes through is that it stands in the shoes of the local authority at the time that the tribunal hearing takes place. It's remaking that decision there and then, acting as a first instance decision maker, and you've had various judicial endorsements of that. Most recently, I've quoted the A&A case, Judge Stout in the Upper Tribunal, where she explicitly describes the tribunal as a first instance decision maker, and going back towards Lord Justice Sedley in the Bromley case. So the reason why I say the reason why I make this point is that the tribunal performs a particular purpose. It, as Lord Justice Sedley says, recasts an EHC plan, although he was talking in the context of statements. And practically speaking, its function is a practical one. It makes moving forward decisions to ensure that children have the right decisions made with them, the right provision, the right description of needs, and in appropriate cases, the right school place. That is what it does. It changes the nature of that function, in my respectful submission, if what you are actually doing is asking the tribunal to analyse everything that has gone wrong, potentially, in a process leading to the decision that is under appeal. That actually has practical consequences on the tribunal in the sense of complexity of appeals and the time it's going to take to deal with them. There may be many cases, and I've cited other examples in my skeleton argument, where there are mandatory procedural requirements to do with timescales or in other contexts, consultations, where a ramification of Judge West's decision is individuals will be asking a tribunal not just to make the decision in the here and now, but to analyse the extent of procedural breach that probably happened well over a year before the tribunal hearing. Because the reality of hearings in this jurisdiction, your lordships and ladyship may be aware, is it takes about a year to get to the FTT at the moment from a decision. So if...
Quicker than getting your JR on.
Well, not necessarily. The court has repeatedly recognised that matters involving the education of children is your quintessential example of where urgency and expedition is needed in judicial review. So actually, and whilst it is the case that judicial review isn't always quick, it has the procedural flexibility to be so.
Can I be completely clear?
Yes.
Is it your position that the remedy in case of a procedural failing, such as we have in this case, is and is only JR?
No.
Is it your position that JR has to precede any access to the tribunal?
It could be done concurrently. The R and the Crown W case in Hertfordshire was an example of that.
Surely, if you go to the administrative court with a procedural thing like this, isn't the administrative court going to say, "This is what the tribunal's for. You've got an alternative remedy"?
Well, in that, if I could, before I address that, in answer more fully to your first judicial review isn't the only answer in these situations, because of course local authorities have to maintain complaints procedures, and then, as your lordship is familiar with, there is the LGSCA, and those offer different types of...
Remember, we didn't all sit on the Melbourne case.
No, of course I'm aware of that, and sorry, I should have been clearer, but I was referring to Justice Stewart.
You shouldn't assume I remember what I decided last year.
I've certainly made that assumption. But options exist, and different types of remedies, financial, apologies, etc., can come from those sorts of options which judicial review wouldn't offer. But you have, for example, on the alternative remedy point, the W case, which is in the authorities bundle, starting at page 439.
Got a tab number for that?
Yes, it's for me at least 22.
Thank you.
Pardon me?
That's Milburn.
For me, it's 23, but that's all right. Page 439, anyway.
Yes, it starts at page 439, and the relevant aspect is at 448. Going over the page to 449 and paragraphs 31, 32, and 33. So 31, it summarises as David Locke Casey sitting as a deputy judge in the High Court that the local authority argued that the 2014 Act was a comprehensive statutory code such that there was no room for judicial review. And you'll see at 32, it said that might raise an arguable defence if a parent was able to appeal to the tribunal about a failure of a local authority to complete an assessment and prepare an EHC plan within the time period specified. But it goes on to say at the bottom of that page, in my judgment, that submission is wrong and has no merit. And then over the page, it's explained that Mr. Straker KC then accepted that whilst a local authority agreed to undertake an assessment but failed to complete it with the times in the time period specified in the scheme, that failure could not be subject to a complaint to the FTT. That concession has been rightly made, the judge said. So that's different context, but it's an example where there's a mandatory requirement to complete an assessment in a period of time. There is a judicial review about that because there's not a right of appeal against that. And as is seen in this decision, there were also ongoing tribunal proceedings. And in my submission, that demonstrates that there is a difference between what the tribunal, in what I say is the orthodox position, does in an appeal, and the delineation between that and matters of public law outside of its statutory jurisdiction, in relation to which consultation is an example. And the other case in my submission which supports that, which is a recent decision, is another Upper Tribunal authority by Judge Stout, the M and Greenwich case.
Sorry, before we leave
Yes.
somebody I'm thinking about it, apart from the fact that a point decided in the administrative court by a deputy judge on the basis of a concession, although both Mr. Straker and Mr. Locke are very distinguished practitioners in the field, but A, so what, and B, I would have a bit conceptual difficulty with the idea of an appeal to the First-tier Tribunal against a local authority's failure to do something on time. What's the decision that you're appealing against?
I accept that that's obviously different in its nature, but the reason why I refer you to it is in my say a recognition, as you say, from a distinguished public lawyer sitting as a deputy judge, that there is a delineation between matters of procedure where breaches of them can be dealt with through judicial review, although not necessarily, it might be dealt with subsequently through an LGSCO complaint, and the function of the tribunal. I don't put that case any higher than that. I accept that the context of it is different to the present case. The next case that I wish to refer your lordships and ladyships to is a bit closer, although not exactly the same either. If I may take you to page 551.
551.
Yes.
Thank you. MM.
Indeed. And it's a long decision, and it's generally about the powers of the tribunal in respect of health and social care recommendations, and there are other issues around capacity dealt with it, but it's subparagraph E on that page that I refer to. So it's Judge Stout says that the tribunal is not, however, required before determining what to order should be specified in sections B and F. So just pausing there, those are education aspects of the plan. Or what to recommend should be specified in C, D, G, and H. Those are the social care and health aspects of the plan. To ensure that the various statutory steps that the local authority should have carried out before making or amending the EHCP are completed, it's well established that the fact of the 2014 regulations by obtaining the necessary advice as to education, health and care, social care in the course of the assessment or as part of a review before making or amending the plan does not prevent the tribunal from making a determination in respect of sections B, F and I, so education needs, provision and placement. And then she goes on to hold, if you skip a sentence, so far as the tribunal is concerned, these assessments are not necessary preconditions to the exercise of its jurisdiction, but merely one means by which the evidence may be put before it. Now there is a symmetry in my respectful submission between that and what I'm saying in the present case. I accept that we're talking about a different statutory gateway here. It's a cease to maintain decision here, whereas there it's about assessment. But that she is talking about the requirements for procuring evidence and views, and actually those regulations do also require the views of parents and children to be taken into account, and also, as we've already looked at, Section 19 requires this. And that is not dissimilar in my respectful submission to what we're talking about here. But what she's saying, and this is, as far as I'm aware, the most recent, along with the other case, AA, that I've referred to elsewhere, the most recent expositions of the tribunal's jurisdiction by experienced judges within it. She is saying, well, what the tribunal does, if you read her two judgments together, is stands in the shoes of the local authority at the time the appeal is made. It exercises its jurisdiction at that time inquisitorially and using its expertise, and it remakes a decision. It's not. I would say that this supports our submission that it is not the function of the tribunal properly understood to be acting as, in effect, a forum whereby complaints about procedural failings are given precedence over actually making the right decision for children in a time-limited sense for the meeting of their needs. Because the tribunal, and again I think this goes to the concern raised by your lordships about the importance of consultation, if one accepts that what the tribunal does is makes the decision in the way that I've just described, then any detriment caused by the failing to consult at the original time is, in my respectful submission, remedied by, firstly, Section 45(5), which stays the decision, the implementation of the decision, but secondly and importantly, the safeguard of the appeal itself, where the tribunal takes into account the views. And my lordship, Lord Justice Stuart-Smith, you made the point, I think it's at paragraph 45 of Milburn, that it would be inconceivable for the tribunal not to take into account the views of the tribunal.
That's where I was just about to go, because I'm becoming unclear,
Yes.
if I was ever clear, about where this submission goes. Because an appeal to the tribunal will either be, in this particular jurisdiction, will either be you haven't made a plan and you should have done, or you've made a plan that you shouldn't have, which is wrong in some respect. Am I right so far? Broadly speaking.
Broadly speaking, there are, but yes, broadly speaking.
So, whether or not, after your submissions on Soneji, we were to decide that the remedy for these procedural requirements, breach of these procedural requirements, is quashing, whether by the administrative court or by the mechanism of a de novo appeal in the tribunal. Two questions. Even if it's not mandatory in that sense, it must be relevant to a consideration on an appeal as to whether a plan should have been entered into or what the terms should have been. So why does this matter?
Well, I would pose the question, what in response to that, what at the time of an appeal hearing, which I've already said is likely to be a year down the line, why is it relevant for the tribunal to engage with those questions when it will have generally have updated evidence?
I thought you were going. I must admit, I thought you were going to that as a sort of lifeline, because if, as this court has held recently, and I think I might even have written a judgment on it.
Yeah.
And it might. I don't think it's Melbourne, but if the effect of the appeal to the tribunal is that the tribunal is then expected to take into account all matters, and thereby remedy the absence of the failure, the previous procedural failure.
Yes.
Then you've got a coherent structure, and it doesn't matter for this analysis whether you say that the procedural breach is or could of itself be a ground for quashing the original decision, or whether you just say it's a material feature to be taken into account to whatever extent possible. Because the end result that we're heading for as I thought you were heading for, is you have an appeal to the tribunal which deals with the difficulties created, or if any difficulties, by the procedural error. And that is a submission that, speaking entirely for myself, I would be receptive to.
Yeah.
But it doesn't seem to me to depend upon close analysis of whether under Sonegi any breach is automatically invalidating and you ought to go to the administrative court and so on and so on. So that you know, again, from my personal view, is that if you, in a case such as this, went to the administrative court and said, they've failed with these procedural requirements, please quash it, full stop, you would get a very short response, which is you've got an alternative remedy and go to the tribunal. So that's a rather long-winded way of saying that I can, in one sense, I have sympathy with your submission, but the key to it may be that the tribunal remedies the deficiency by doing a de novo appeal.
Yes.
And so, and your answer to that should be, it's done.
Well, I mean, I do say that, and I've referred in my skeleton argument to the de novo nature of that appeal jurisdiction. So to be clear, and I apologise if I haven't been, that is my point, that the tribunal function in how it operates addresses this problem because the scheme has to be looked at as a whole, and the end point of an appeal is made is not the local authority's decision, it's the appeal and the tribunal standing in its shoes. And to the extent that there's procedural defects that arise, that I've used the loose analogy of Calvin and Carr, but it cures the defect because it gives a fresh opportunity, at that point, standing in the local authority's shoes to reach a fresh determination. And so in that sense, a tribunal shouldn't be deciding an appeal purely on the basis, as we saw in this case, of the procedural defect, because that ignores the wider merits of everything else.
If your submission is that the first-tier tribunal should ignore everything else once it finds a procedural error, speaking entirely for myself, you don't need to press that submission. I can accept that.
Yes, okay.
But you've made it clearer, to me at any rate, that your submission is that whatever the theoretical consequence of a procedural irregularity, such as we're dealing with, it's swept up by the tribunal de novo appeal.
Yes, and because of that de novo appeal, looking at section 51, is against the decision that was made, and so it's the statute that directs the primary focus of the tribunal's question. In this particular case, it was, is the child... Is the local authority responsible for the child? In other cases, it will be, and probably the vast majority, what is the description of need, what is the provision that's required, and what is the placement, and that decision is made at that time. So that does reflect my position, but the reason I bring in, and it may be that I appreciate that as a personal view expressed by your lordship. I'm not inviting.
Well, it's certainly not the expressed view of the court.
No, exactly. But if hypothetically that is the position that we are in, then I submit that round one has to succeed because the first-tier tribunal didn't approach its appellate jurisdiction in that way, and nor did the Upper Tribunal by endorsing the decision that had been made by the First-tier Tribunal, which was restricted to this procedural breach analysis. Now, the reason why I dealt with Sonegi was to say, to the extent that your lordships and ladyship are of the view that the procedural breach, in this case consultation, whatever it is in another case, can be considered in the way that the tribunal and Upper Tribunal have here, then it's not enough to simply say, because it's a mandatory requirement, it follows that the decision is invalidated. And that is where I say a more nuanced approach at the statutory scheme has to be looked at, which wasn't done by the First-tier Tribunal or the Upper Tribunal, and you have to look at what the what the intended consequences of the breach were. And in my submission, on that approach, there is only one answer here based on the factors within section 45 that I have already referred to. If one approaches it on that basis, then the conclusion should be that there wasn't total invalidation here, because that's not intended by the parliamentary scheme, and therefore more is needed to address the substance of the decision on its merits. And that is not something that the tribunal below or the upper tribunal, in my respectful submission, took.
Yes, and this may be a rather amateurish way of looking at it. It seems to me that you're probably right that the procedural flaw doesn't invalidate the decision in itself, and what would be the purpose of that on these facts? I mean, we'll shortly get on to the, as I think, more interesting ground 2. But if you're right in law that T ceased to be, quote, in the area, and Hampshire were entitled to say, he's got nothing to do with us anymore, if you're right about that, then the procedural flaw would have led the respondent family nowhere.
Yes.
On the other hand, if you're wrong about that, then they win the case anyway.
Yeah, if I'm wrong on the procedural point, then I...
No, if you're
If
wrong
I'm wrong on the
substance,
ordinary residence point, well,
if your grounds 2 and 3 fail,
yes, I understand.
the procedural point might be interesting in another case, but it's not interesting at all in this case.
I think there is an interaction between each of these grounds, and say that's likely to be right. I mean, if the conclusion is that ordinary residence is the right approach, then I'm in the position of having to say that applying ordinary residence, the decision of the upper tribunal was wrong, which it is a point I take, although it's not my main point, and it's I appreciate not the easiest. So I say that obviously the approach, and we'll come to that momentarily, on ordinary residence just shouldn't have been applied. Full stop.
Yes.
But I accept. I think I would have to accept the forward-thinking analysis that your lordship has taken us through there.
You're not, I think your position in answer to Lord Justice Stuart-Smith's questions was, you're not saying that the FTT has to ignore failure to consult as though it had never happened. It could reinforce a child or a family's case on the facts. If that it is said, if you had consulted, you would have discovered that they had this intention to return, it was short term, etc., etc. That could legitimately feed into the FTT's consideration of the appeal on the merits.
And assuming that isn't the be-all and end-all, as is the approach that we saw here, where the analysis stopped at procedural defect, then there may be cases where that has some scope to be applied, but it should never be the end point. And we say, actually, the reality is that it's likely that sort of question, well, we say it's highly likely that sort of question will ever be determinative of the appeal, and it's also unlikely that it will have, if any, or high relevance for the reason that whatever may have been the case at the time of the failure, things could well be different, and probably are different by the time of the appeal hearing, and it's assessing the things at the time of the appeal hearing which the tribunal is concerned with. As I've already referred to, there may well be entirely new evidence available at that point in time. And so, in a case like that, the difficulty caused by the prejudice is very, the difficulty caused by the failure to consult is very much overtaken by what the parties have done in the meantime. And that is the usual order of things. Tribunals set down directions for evidence. This is a jurisdiction. I appreciate this case doesn't necessarily reflect its typical scenario, but the parties will often engage experts and will have a variety of other evidence available to it that are not available to the local authority at the time of its decision, just because it would be impossible to have it, regardless of whether a consultation took place. So the tribunal in the here and now performs the standing in shoes function, but on the basis of potentially very different evidence that's available to the local authority when it makes its initial decision, which in my submission supports what I say is a more orthodox understanding of what the tribunal does.
Well, you haven't dealt with Synergy. Do you want to make? He hasn't.
I mean, I can take.
You've dealt with it fully in your skeleton.
I mean, I can deal with it more fully now if it's of assistance to your lordships and ladyship. And I think the point in my skeleton arguments I would at least hope is made clearly, but I can take you to the relevant passages if we need to go there, and I'm very happy to do that. But I deal with it at page 238 of the core bundle. I would invite your lordship to start at 34, where I'm making the point I've made to your lordships in all submissions about what we say the normal approach for tribunal is, and then I give the quote, the relevant quote from Synergy there at 35.
There's a decision of Lord Justice Etherton, I think when he was Master of the Rolls, where he summarises all this, which I haven't looked up, but I'll find it and let you have it.
Well, you've
I'm grateful.
made the point in argument, without having to lean on Lord Steyne and Synergy, that you say look at the relevant sections of the 2014 Act. You say it is clear Parliament did not intend that failure to consult though in breach of Regulation 31 should lead to total invalidity.
Yes. Yes, I make the point firstly because consultation is just that. It doesn't direct or dictate the outcome. I refer also to the fact of the existence of a right of appeal, and I also refer to section 45(4), which, as I've put it in my own language, stays the implementation of the cease to maintain decision pending the outcome of the appeal. So those are the factors within the statutory scheme that I rely on the Synergy approach. Of course, your lordship will forgive me in terms of the decision referred to by Lord Justice Etherington. I don't have that immediately to hand, but your lordships will. We can try and find it if it's helpful. But your lordships might be aware that the Supreme Court last year in A1 Property Sunderland, in the private law context, looked at Synergy and endorsed its application as to statutory interpretation there. So we say that this is a principle that both has rich heritage but also has recently been endorsed.
All right. I think we're done with ground one for the moment. Let's go on to ground two.
Yes, very well, your lordships. So ground two deals with the in the area question for the purposes of section 24 of the Children and Families Act. The question being, what is the test for determining whether a child or young person is in the local authority's area? And as you will have read, it was found by Judge West to be an ordinary or habitual residence test. Those terms are used not just by Judge West, but probably for convenience by the parties as well, interchangeably. But I do recognise they are different concepts, and I think, in fairness to Judge West, he does say to the extent there is difference between the Shah approach and the A&A approach. My reading is that it's the A&A approach that he is attempting to use. It's quoted extensively in his decision. So I just flagged that at the early stage to say that those are two terms that are used within his judgment, but they don't necessarily connote the same thing, although they're very closely aligned. The key aspects of his decision, if we start out with the decision itself on this point, start at paragraph 199, which is at page 144 of the core bundle.
Sorry, could you give me the page number again?
Yes, my lord, it's page 144.
Thank you.
So Judge West says here that he's satisfied that the provision in section 24 of the 2014 Act, which stipulates that when a local authority is responsible for the child in the authority's area who's been identified by the authority as someone who has or may have special educational needs, that includes a person who is ordinarily or habitually resident in that area but temporarily absent. It follows that if the child or young person is ordinarily or habitually resident in the authority's area, notwithstanding such temporary absence elsewhere, local authority remains responsible. And he says further below that the 2014 Act imports an ordinary or habitual residence test. And there are other aspects of the decision where this comes to the fore. There's obviously lengthy extracts from case law, but at, for example, paragraph 221 on page 153, you'll see that under the title application of the ordinary habitual residence test, the decision proceeds on the basis that the correct test is ordinary or habitual residence, citing the speeches of Lady Hale and Lord Hughes in the A&A case. And at paragraph 228 at page 158, this links in with the previous ground, but we can see a finding that T was in the local authority's area because he was ordinarily resident in that area. The other material aspects, the case I'll come to is the case of G and Kent. We can see in the decision of Judge West at paragraph 206, which is at page 146, he quotes Mr. Justice Nicol at 205, where he says that ordinary residents can provide assistance, but as we'll see in that decision, he doesn't go so far as to say it is the exclusive test. And at 206, Judge West says that he would go further on the correct interpretation of the statute. Ordinary or habitual residence is the test.
What do you say is the test?
We say that this is, well, we say that the question is answered through statutory interpretation, and the words of the statute in the local authority's area are clear and mean what they say and don't need further gloss. So in the area,
people always say
in the
that.
area.
But you just mean physically present.
Well,
Or do you want to gloss it?
I don't wish to gloss it. In the area means in the area, and I say that is a matter of discretionary judgment for local authorities.
So within the physical boundaries of Hampshire.
Well, there may be cases, in my submission, the vast majority of cases, that will be the case because people are resident where they live and go to school. And so the significant number of cases will be answered through physical presence. I've read Mr. Gillies' skeleton argument, and it proceeds on the basis that my submission is physical presence.
Well, that's what it says in the judgment, that was your submission.
No, it does, although I have to make absolutely clear that the argument that I am making now, that this is a matter of discretionary judgment for local authorities,
So you're moving away from what your submission was at first instance.
This was my submission at first instance. I appreciate. I've read that point as well, my lady. I appreciate what it says, but I made it very clear in all the submissions. I checked additional written submissions that I made to the Upper Tribunal as well. I certainly had discourse with Judge West on this point. Our case is that this is a matter for local authorities which should be unfettered. It is for them to decide whether an individual is or isn't in their area, and physical presence is a prominent factor in that. If your lordships are of the view that it needs to be interpreted in another way, then we say it's not ordinary residence or habitual residence that applies. If it has to mean something, then that is where I say physical presence. But either way, in my submission, you look at it, the vast majority of cases are cases where presence is going to be the vital factor. That is the reality. There are exceptional other types of cases where physical presence might not, and there might be a variety of other factors that need to be looked at, but that doesn't mean that you read in
Give me an
ordinary
example.
residence.
If we've got presence at one end and ordinary residence at the other, and you're saying, well, no, I'm not saying presence is an absolute, there may be something else. I just haven't got it in my head what that something else might be.
Well, the statutory language is in the area of the local authority, and so that is the answer to the question. As a matter of statutory construction, it doesn't need further gloss beyond.
You keep coming back to that, Mr. Lyon. If
Yes,
you don't mind my saying so. It's rather a comfort blanket, but it doesn't answer the question. In the area when, on the day of the decision, supposing the family have gone away for a week's holiday in the neighbouring county, you wouldn't say that the child ceases to be in the area.
On either approach we're looking at, or at opposite ends of the spectrum, as my lady put it, we are not suggesting, and I don't think anyone is suggesting, that genuinely temporary absence of the matter of the nature that your lordship is discussing here would result in a different decision, whichever way the test operates. It's going to be the home, if I can characterise it in that way, local authority, that is responsible for maintaining the plan.
You might determine what, because someone's going to have to decide whether they're present or not, and a nice, easy, straightforward way to decide whether they're present is by deciding whether they're ordinarily resident.
But as I say, in the majority of cases, that's not going to arise as a consideration, and it's not helpful to start looking at these cases.
But the reason why you're in the Court of Appeal is because difficult cases emerge, and my Lord has asked you, what effectively, what are the criteria? And it's no good saying the great majority of cases are simple, or if you just go for a holiday to Dorset for a week, that doesn't count. This appeal is here with a view to us providing some useful guidance.
Yes, I appreciate that, my Lord.
So what do you say are the criteria that determine whether a person is to be regarded as being within the area for the purposes of the statute?
If that is the approach that your lordships take, then we say that the essential and important criteria is physical presence.
Essential?
The important... Your lordship is very fair.
You'll have to forgive me, but you must provide us with an explanation that we can either accept or reject or modify.
Well, yes, and my starting position is that is what I've said. But if the criteria needs to be there, then presence is what I rely on, and that is where I would have got with my submissions. But your lordships are right to pin me to it, and I appreciate why your lordships and ladyship are doing that. But I don't say that is the end of the matter, because I don't buy.
What is presence?
Well, what is presence, and I don't mean by presence a de minimis rule whereby if a child who's in Hampshire goes on holiday to Northumberland for a few weeks, they are suddenly the responsibility of that local authority. That's not a practical application of the test that's being discussed here, and it's not a reflection of reality either. So that doesn't respectfully arise, whilst it's worth looking at as a problem that we, in my submission, need to concern ourselves. The vast majority of cases in this context will involve children and young people with EHC plans who live in an area and go to school in the area that they live. That is not a problematic area as well, but it is the vast majority of cases. And whether you're looking at it from a presence perspective or you're looking at it from an ordinary residence perspective, the answer in those cases is going to be the same. And so for those cases, it's not helpful to import generally an interpretation of ordinary residence into Section 24 because it doesn't serve really a practical purpose.
So we're not helped, are we, by the fact that in care proceedings, when a dispute arises about which is to be the designated local authority under the Children Act, ordinary residence is the criteria for determination?
Under Section 17, my understanding of the...
No, I'm not talking about Section 17.
I appreciate another context there.
I'm talking about when the dispute arises.
Well, the Children Act is obviously separate legislation.
I'm just wondering if it helps us at all where a dispute arises about the provision of services.
Yes.
In those cases about care proceedings for a child, and the issue arises about, well, should it be local authority A or local authority B?
Yes.
One looks at the ordinary residence.
I mean, yes.
But you're saying this is, although you're still talking about services for children in need, I know they're not notionally Section 17, but they would be Section 17 children, these children.
Yes.
That rather than ordinary residence, which would apply in those circumstances, presence, mere presence, physical presence, I think is how you put it, is the application in this case.
Well, I think that the starting point difference is that the Children Act does expressly refer to ordinary residence. That is not the case in the Children and Families Act. So again, starting at basics, but important basics, I would say that is the clear distinction. Your ladyship will be vastly more experienced of care proceedings as an area of law than I am, but I would suggest that these are different areas of decision making which don't command necessarily the same questions and answers. One has to be directed to, firstly, what the statute says, and here in my submission it's plain that Section 24 doesn't refer to ordinary or habitual residence, neither did the equivalent position under the Education Act prior to it. I also refer to the regulations, and we have this in my skeleton argument as well, which is the easiest place to take it from.
Yes.
Regulation 15. Which paragraph? Paragraph 40.
Paragraph 40, did you say?
Yes, it's paragraph 17 at 231.
Thank you.
Regulation 15, I summarise the position. We obviously have the regulations in the authorities bundle if we need to look at them. Addresses the transfer of responsibility for EHC plans where a young person moves into a new local authority area. And and so there's a statutory mechanism in place for when a child or young person moves from local authority A to local authority B on a basis that has the sufficient degree of permanency for that EHC plan to move with the individual. And that is another difference between, coming back to your questions, my lady, as best I can assist, difference between the care situation and the education situation, whereas my understanding is that under habitual ordinary residence it might be possible to have a presence that satisfies the test in more than one place. Here, the intention of the scheme is that there will only be one local authority that has the responsibility for an EHC plan.
If the wording is moves, depends what you mean by move. I mean, for ordinary family where either or both of the parents who are working in civilian life, you move to take up a new job, move from Aldershot to Newcastle, say.
Yes.
That's not going to be temporary. But if you change the facts to some time-limited attachment, it might be less easy.
Move from Shribberham to...
This is why, and I appreciate your lordship's expressed difficulty with my opening gambit, as it were, but this is why these are areas of discretional judgment. And I do accept under habitual residence that is an area of judgment as well. It's directed at a factual assessment. But I say, why do you need to imbue the language of Section 24 with an ordinary residence test that might potentially give you some pointers and be helpful on cases on the margins, but actually in the vast majority of cases isn't going to be a helpful test to direct the analysis to. And even if you did, you'd probably result in the same answer anyway. I think it's Lord Hughes in A&A that recognised that whilst presence isn't necessary for the for a habitual residence test to be accomplished, in the majority of cases you will have presence where you are resident, and so actually those are things that will often be seen together. But we say that's the reality of this situation. Now, what you see in practice as a matter of development is that because there are cases at the margins, of course there are, not every case is the same. There will always be exceptions to the general rule, but that can be dealt with as a matter of guidance, and we can see that guidance has been developed to deal with those sorts of cases. Mr. Gilly he identifies two situations where ordinary residence apparently provides an answer which my approach doesn't. But those are looked after children and service families, both important sets of both important areas. People in those areas have just the same rights, of course, as the general population, but there are individual factors to them. And the majority of people are not service families, and even a majority of children of EHC plans are not those who are in Section 20 accommodation.
I bet there's a disproportionate number, though.
Well, actually,
No?
my understanding of the position is that if you're a looked after child, you disproportionately are likely to have special educational needs. That's absolutely right. But as to
all I'm saying is you can't regard those as being on the margins.
I do not seek to suggest that those are not important cases, and they need to be treated with the utmost importance, of course, for reasons that I don't need to go into, and indeed are. The point I am making, though, is what is being proposed on the other side, and as has been endorsed by Judge West, is that as a matter of interpretation, Section 24 in the area means ordinary residence. And this court, in my respectful submission, should be very careful and slow to imbue those words with a statutory meaning that is being applied in what are reasonably exceptional cases compared to the majority of cases that this area are affected by. And even within those classes, it's not always. So Mr. Gilly and Ms. Swords-Keeley give an example in the looked after context in their skeleton argument, which perhaps we can turn to because it may provide assistance at page 266. Of a child or young person starting off as a looked after child in authority A, who is then placed in several placements over a 6-month period outside of local authority A, but then eventually returns to local authority A when a secure foster care placement has been identified. Now, I'll draw on the facts in a minute of that example, but not every case in front of a local authority concerning a looked after child, and I appreciate those are difficult cases and there will often be some disruption in relation to them by their very nature, but not every looked after child will at a given moment have an unstable accommodation situation. There might be a secure foster placement where actually a looked after child is happily looked after and is long term. I understand these are complex areas. I'm not suggesting all of them are like that.
Perhaps you can, to help us from a practical point of view,
Yes.
does your local authority stop the assessment and the services that are provided under it if a child moves to a foster care outside the borough?
So this is where the guide. So a point and I can check for instructions if I need to answer that fully. But there is guidance both under, there's 2009 Department of Children, Families and Skills guidance that was initially there and now more currently under the SEN Code of Practice. And the short answer is that, as I understand it, is that it can depend. So if an individual is placed by a corporate parent outside of the local authority into secure accommodation, not secure accommodation, in accommodation that is secure, stable, etc. Then, in terms of an assessment duty, if it arises at that point, what the SEN Code of Practice says is that it's the local authority where the child is placed that has that responsibility.
I'm sorry, I'm really not talking about long-term foster placements, which are the minority, of course.
Yes.
Most placements are short-term, and sadly, a lot of local authorities have to place out of borough.
Yes.
And a lot of placements break down, and
They do.
children are moved all the time. So, I was just asking whether or not the policy of your local authority is that when a child moves out of is placed with foster carers outside of borough, they withdraw the EHCP.
May I take
because
instructions?
Because they're no longer present.
Yes.
Yes, of course you may.
I think I have an answer, but I wish to take instructions on it before I do.
Of course.
Grateful.
Sorry, I didn't mean to bounce it on you.
This is an area of complexity, as your ladyship will know, and it does really depend on the circumstances. In cases of genuinely short-term duration, it would not be the local authority's position to cease responsibility under Section 24 of the Children Act. However, if it were the case that outside of the area a long-term and stable placement is put in place, then that can be a situation. But it wouldn't be a cease-to-maintain situation, just to be clear.
It would be a transfer.
It would be a transfer.
Yep, I understand.
So it does depend respectfully, and we have the.
Putting it another way, in the scenario set out in paragraph 20 of
Yes.
Mr. Gilly and Miss Swords Keeley's skeleton argument. The child, in the course of 6 months, is placed in local authority B, C and D, then back to A.
Yeah.
The child remains the responsibility of A, and any plan remains in force.
Yes, and which is why scenarios like this, whilst helpful to look at, don't undermine the position we take, because our position would be, in this example, it's clearly a series of short-term and unstable moves, and it would not be the position that, even though that child is temporarily out of the area, that the presence test or the exercise of general discretion would undermine the local authority retaining responsibility. And the point I wish to build upon in relation to that is, the reality is that in these difficult cases, which are not most cases, particular guidance and practices are developed, and we see that reflected in Chapter 10 of the SEN Code of Practice. So if I could ask your Lordships and Ladyship to turn to page 610 of the Authorities Bundle. You will see there that this is, in its title, covering specific circumstances, which includes looked after children, but you will see there are various other areas which are potentially, and in many cases going to be likely to be before local authorities, but require particular considerations that don't necessarily apply to the generality. And that includes, you will see in the penultimate bullet point, service personnel. But there are others. Now, for looked after children, there is particular guidance starting over the page at 611.
Oh, I was right. 70% of looked after children. Some form of special.
Yes, which is why I said a very high proportion of looked after children, it's recognised, will have SEN. So that's likely to be higher than the general population, without knowing the percentage figures. But I have no difficulty in accepting that. But the percentage of EHC plans which are attributable to looked after children is likely, well, as far as we understand, is not in that order. I do have, if your ladyship is interested, I do have instructions on figures within the area of Hampshire.
I don't want to take everyone off course.
Be that as it may, the point here is that what we have is a section of the Code of Practice which is separately set out from the main sections that generally deal with the SEN functions for particular cases. And you have an example, for example, at paragraph 10.8 at 612, of the situation with children living with foster carers or in children's homes, which your ladyship has referred to. And bear in mind, this is discussing assessment, but it's saying if an assessment duty arises, so that will be where an individual hasn't previously presented as having SEN, but then does, that is carried out where the child lives. Now it then says, i.e. is ordinarily resident. But this is my point. Firstly, I don't think that's very helpful. And remember, the Code of Practice.
It's certainly not helpful to you.
Well, I would say that actually what it's really describing is presence. But the fact that it says ordinarily resident might on its face seem not very helpful to me, but when one views this in the context of a very specific situation, and bear in mind you haven't been provided with any other chapter within the SEN Code of Practice, which is over 300 pages long, because it doesn't
Thank you
refer
for
to.
sparing us.
Well, at one point there was discussion about it, but we thought it was ill-advised.
688 pages of authorities is enough to be getting on with, I think.
We thought your lordship might reach that conclusion. But the point is that ordinarily resident isn't a term that you see littered through the Code of Practice. And it's not a way in which Section 24 is described. In particular cases, and having read Chapter 10, I think the only sections it arises in is in relation to looked after children and those who are in custody, because of course you might be detained in custody in an area that you're not usually living. The term ordinarily resident is made, but we say that's because it's catering for particular circumstances. That doesn't mean that ordinary residence is the test under Section 24. It just means that different practices, perhaps guided through statutory and non-statutory guidance, find, in the words of Mr. Justice Nicol in the Kent case, they provide helpful indirect pointers. And you can see there is also at page 616 a section for children and people educated out of area. Now, that could include looked after children, but isn't limited to that. But where you have the situation of an individual who is in local authority A, but is, because of a school that is named in section I of a plan, educated outside of area, for example, there might be a residential placement, or there might be a school for particularly complex needs that the local authority doesn't have in its own area, it remains the home local authority that has the responsibility. And that is because in most cases, the family of the child will remain in that area, or in a Section 20 case, the corporate parent will be that local authority area. But this just goes to show that Section 24 doesn't mean ordinary residence. If it did, the statute itself, but not least the Code of Practice, could spell that out. It simply means that for particular cases, there are approaches that, in a very limited set of circumstances, ordinary residence principles provide guidance, but not more than that.
We don't need to worry much about the case where the family go on holiday during the school holidays,
I don't
because
think so.
home, the two things that you've picked up on as indicators, I think, are living in the area and going to school.
Yes.
Some while ago. Can I just ask you to consider a slightly different set of facts, which aren't quite our set of facts?
I shall do my best.
Thank you. So take a case where the father is deployed to Dubai, not necessarily as a service father, but the father is deployed, and the family go to live to that place for one school term. And that's the intended duration of the deployment, and they're intending to come back to their home in Hampshire, whether they've rented out or not during the period that they're away. I can see that there could be different answers to the question. No, let me just keep it simple. And there is a plan in place.
Yes.
What happens during that period?
Well, that is a period where, for a relatively short period of term, a school term is not more than a few months. And I assume within your stated set of hypothetical facts, Your Lordship, that the family expressed to the local authority that is their intention, yeah. then it would seem, on my analysis, surprising, and I think it highly unlikely that a local authority would decide they're going to cease to maintain the plan, because it's known that within a relatively short period, within the cycle as well of an EHC plan, because let's not forget that an EHC plan is only worth a year until its next annual review, that child is going to come back. Moreover, because it's a service family, the local authority, as was the case here, would be cognizant of its duties under the Armed Services Covenant, and that's another example of where in particular cases, particular considerations can be used to meet the complications. So in that situation, we would say it's highly likely that the local authority, appraised of all the relevant facts, would simply conclude that it remains responsible because the child, after a few months, is going to return and therefore remains in the area. Now, that is a different scenario to where an individual in those circumstances is away for 2 or 3 years.
But my lord's example, therefore, is that your local authority would be making that decision by reference to ordinary residence, not presence.
But it wouldn't strictly have to apply ordinary residence to reach that conclusion, is my point.
They certainly couldn't get there by presence, could they?
Well, it could get there by presence by concluding for a short-term, temporary period, genuinely and assessed to be.
Not present.
Not literally present, I accept that, but my point has always been that presence doesn't have to, it's not an inflexible concept for local authorities.
Why, when you've got a lovely, perfectly flexible, well-recognised thing in ordinary residence,
Yes.
would you choose something different and then try and flex it into something it isn't?
Well, I think the opposite is happening. In my respectful submission, the test doesn't include ordinary residence on its face at all. We're asking local authorities to apply. In my submission, the focus, whilst it has to be on, because of this case, on service cases, a consequence would also be applying ordinary residence across the board.
And we say, because that scoops up all those presents as well. That it would include your physical presence also.
But we say it's the starting point is it's not necessary within the statutory language or how that's been interpreted, but nor is it necessary to do that because a local authority doesn't need to be bound by ordinary residence to reach a conclusion that an absence is temporary. And this is why I said at the beginning, it may well be that the same conclusion, regardless of the approach.
I'm starting at the other end.
Yes.
And I'm having real difficulty. I'm quite clear in my own mind that physical presence is not determinative. So when you go on holiday to Dorset or Northumbria or Dubai, you don't fall out of the scheme. That's easy. And it's still easy if you say, well, subject to de minimis, because that was really the point of my suggested case about going to Dubai for a term, because that's well beyond de minimis. That's not a holiday. What I'm having real difficulty, and still having real difficulty, and I think it's partly because you're insisting on starting by trying to tether it to presence, is what the criteria are. Because it's no good saying it's an evaluative, unfettered decision to be taken by the local authority, because the next people who read this case will say, well, what on earth does that mean? Or how do we deal with this? And how does
the present situation under Mr. Justice Nichols' case, and we can look at the Kent case, is that he accepts that ordinary residents might, in appropriate cases, provide indirect pointers, and that's what we say is the answer. But that doesn't equate it to requiring ordinary residents to be used in every single case, and that's why we do say it's a matter of discretion for local authorities, subject to public law constraint, obviously, because where the right case is before it and where ordinary residence provides assistance, it may, if it deems it useful to do so, use ordinary residence as an indirect guide to how to reach the decision. And that is effectively what Mr. Justice Nicholl concluded.
Well, we'll look at Mr. Justice Nicholl in a moment, but speaking for myself, I find it very difficult to think that it can be a question of discretion. It may be difficult to say whether somebody is in the area or not, but it can't be a matter of discretion. And as I understand it, my lady will correct me if I'm wrong, because I'm not a family lawyer, where a child is ordinarily resident, there is only one correct answer. You can't say, well, some decision makers would say he's ordinarily resident in Hampshire, and some would say he's ordinarily resident in Dubai or Newcastle or wherever.
Yes.
There is only one right answer.
But a right answer under ordinary residence might be that an individual is ordinarily resident in more than one, or habitual residence. Sorry, that's certainly my understanding. It's what I can perhaps, and I'll stand corrected, but it's certainly something that Mr. Justice Nicol recognised.
All right.
In
we look
his
at
case,
decision.
It may be that that's an appropriate
Yes.
moment to go to that. So it's the Kent case starting at page 346. And it's a lot of the decision isn't relevant for our purposes because there were two judicial review cases, one involving care and the other involving education.
Sorry, could you just give me the reference again, please?
So the start, I was,
19.
it was 346 is the starting page of that authority.
Thank you, I have it.
And moving to the relevant aspects of the decision, if I may ask your lordships and ladyship to turn to 371. And paragraph 119, you will see that there's a title above it, the education claim, meaning of moves for the purposes of Regulation 23, which was a predecessor to the current Regulation 15. There's a summary of the arguments there, and then over the page at 372, you'll see there was discussion about the belonging regulations. We've not gone into that in a great deal of detail, but you'll have noticed that I've commented on those within my skeleton argument. Those are to deal with financial recoupment, and in the amended version of them, which we discussed this morning at Regulation 2.4, it says that they don't apply for the purposes of Section 24 of the Children and Families Act, and those regulations apply at Regulation 2.2, an ordinary residence test. And then over the page at 373, at paragraph 127, you'll see, just to note, you'll see that the Rie case that was also referred to by Judge West and is discussed in both parties' written submissions was taken into account. And then getting to the meat of it at 374, at paragraph 133, Mr. Justice Nicol says he agrees that it's necessary to distinguish a situation where there has been a permanent move from one which is temporary or transitory. There can only be one local authority which is responsible for the child's special educational needs. And he goes on to say, further down, I agree as well that it is of assistance to see whether there's been an alteration of the child's ordinary residence. And then 134, he says at the same time, there are limits to the usefulness of this methodology. The term ordinary residence or habitual residence is not used in the regulation or the enabling statute, and we say that remains the case under the Children and Families Act. And he reiterates there can be only one local authority which is responsible for the child's special needs, whereas a person with ordinary residence in more than one, whereas a person may have ordinary residence in more than one place, which is where I took the comment I made to your lordship
Have you got that case in the bundle?
We don't.
That's okay, I'll look at it over
I'm
the short
afraid.
adjournment.
And then he concludes the features identified in ordinary residence are therefore of no more than indirect pointers.
That's where you get your phrase indirect pointers from.
Yes. Yeah. And I'd say that's consistent with how practice has developed, in the sense that there's not a general set of guidance that's produced in the Code of Practice or elsewhere that says, when looking at in the area question, local authorities should apply an ordinary residence test. Rather, ordinary residence is referred to in particular circumstances. And this was a case, incidentally, about a looked after child. May I have the explanatory notes? You've already given it to us. Just on that point, the explanatory notes to the Children and Families Act, a copy of which was handed up to your lordships and ladyship this morning. At paragraph 176, there is discussion about section 24 and the responsibility question. It doesn't refer to ordinary residents, but it does say this will cover children and young people who live in the area and are educated within it, and those who live in the authority area but are educated outside of it. So in a simple case, child living on the border of another local authority lives in the local authority A, goes to school in local authority B, it will still be local authority A that's responsible, because that's where he lives. This would include, for example, children and young people with an EHC plan from the local authority's area who are placed at an independent or independent school or post-16 college. So it doesn't answer, I accept, obviously, the question categorically, far from it, but it's relevant in the sense that it supports the contention that there's not a general interpretation of ordinary residence within section 24. You don't find that within the explanatory notes, you don't find that within the code of practice, nor do you find it in the case law that has been referred to just a moment ago, the Kent case.
But if assume for a moment what Mr. Justice Nichol says in the passages he referred us to is correct, there can only be one local authority which is responsible for a child's special education needs.
Yes.
The term moves is used further up the page. That can't be a matter of discretion, can it? Either the child has moved or he hasn't.
Well, if the child moves, then that's where what is currently Regulation 15 comes into play, and that says that the old local authority shall transfer the EHC plan to the new local authority. Now, that doesn't preclude disputes arising about where the child is living, but in the vast majority of cases, it's going to be clear because a family will have moved their residence and the EHC plan will follow them by virtue of that regulation. My lords and my lady, because I've mentioned it, it might be helpful to look at the belonging regulations which were referred to in the G and Kent case, and also in Upper Tribunal Judge West's decision. They start, and I think it's a continuum of page 682 on your lordship's version. They got the updated page numbers as well. If it's an assistant, my junior can hand up fresh copies which don't have a continuum of page 600.
But I've only got 2 pages anyway.
Very well.
Thank you.
And I intend to move on from this grounds by at the latest past, which should leave sufficient time to deal with the third ground.
Thank you.
Right.
So these regulations are in place to deal with recoupment where a child or young person is situated in another local authority and that local authority is performing relevant services for the home local authority. They were amended first in 2009 and then subsequently in 2014 to update the position under the Children and Families Act. You'll see at the first at page 682, sub-regulation 2, that references in the regulations to the place where a person is ordinarily resident are references to the address where they are habitually and normally resident.
Apart from temporary or occasional instances.
So yes, precisely that. And at regulation, sub-regulation 4 on page 683, it says these regulations do not apply for the purposes of determining which authority's area a child is in for the purposes of section 321(3) of the Education Act and section 24 of the Children and Families Act. So my submission on these regulations is that it would be strange to insert an amendment to them to make it plain that they don't apply to section 24, which therefore must be included as referring to the test which they incorporate of ordinary residence as defined. It would be strange to do that if actually the test under section 24 as understood was ordinary residence.
These regulations are simply a accounting mechanism.
Yes, they are. They're for financial recruitment, as I understand it, and there are particular circumstances in. You don't have the full regulations, but if your lordships turn to page 49 of the bundle, you have the explanatory notes.
49.
Yes, which I appreciate will require a bit of jumping around, for which I apologise. And there's a list at A to F that gives a bit of insight into the circumstances in which they apply. One, which you'll note at E, is in relation to looked after children. So
which page are you on?
I'm on page 49, my lord.
Thank you.
So my understanding of them is that they provide a process of recoupment so that the local authority in which the child is situated can financially recoup from the from the home local authority where services are being performed on its behalf, effectively. We simply use this as another one of the points in favour of not incorporating ordinary residents generally, because this suggests an intention not to imbue section 24 with ordinary residents, given the disapplication of the regulations, a feature of which is ordinary residence, from section 24, and that was the effect of the amendment in 2009, followed by that in 2014. My lords and my lady, there were some points that I'm not going to have time to address in detail, but I wish to just flag, if I may, for your attention, which again go to this point. The first is the Upper Tribunal, and also in his skeleton argument, Mr. Gilly refers to section 83(6).
Is that Wales?
The Welsh provision, if I can call it that. I've dealt with that in my skeleton argument. Which is at paragraph 41 on page 241. And the short point to make, because I don't have time to develop it further, but the short point is, firstly, it uses the words wholly or mainly. It doesn't actually expressly adopt the term, the words ordinary or habitual residence. And secondly,
where is, sorry, Mr. Gilly,
it's in my skeleton argument,
line
my
I was
lord,
behind
at
you.
page 241 on paragraph 41. And it's a reference to section 83(6), which is an interpretive provision in the Children and Families Act. And it essentially says, and we can go to it if necessary, that a child or young person isn't in a local authority in England if they are wholly or mainly resident in Wales. And we say that's not using the words ordinary or habitual residence, and secondly that it's dealing with a very particular issue rather than generally defining the meaning of section 24. And that issue is the interaction between Wales and England. Part 3 of the Children and Families Act doesn't apply in Wales. In 2014, the 1996 Education Act still applied, and it's now been overtaken by the 2018 additional needs legislation there. My lords and my lady, is there anything else I can assist you with on ground 2?
No, thank you.
Thank you very much. Round 3 deals with the nature and scope of section 42, subsection 2 of the Children and Families Act, which is the duty to secure special educational provision in relation to a plan which a local authority maintains. The relevant aspects of Upper Tribunal Judge West's decision on this, we turn to the core bundle. Are at pages 167 to 168. At paragraph 244, he dealt with the question of freezing or pausing the EHCP, which is wording that Kate was used by the First-tier Tribunal in its decision. And he accepts that those words don't appear in the regulations or the Act.
But it is used by your local authority.
It was initially, that's an entirely right observation. It was initially used by a case officer, although by the time of the First-tier Tribunal hearing, the local authority was explicit in distancing itself from that position. But you're right, my lady, in that that's where the terminology first came from.
Was that unique, or are there a number of cases where they've paused?
Do you mean to say use the terminology of pausing, or,
No,
or actually?
Actually doing it.
Well, I will have to check on that. It's
Oh,
certainly not.
no,
from
your
the standard.
junior's checking.
Yes. My instructions are that that was said in error, and that is not something that the local authority does as a matter of practice. Turning, if I may, back to paragraph 244, Upper Tribunal West said that the tribunal had been saying, in the circumstances of the case, the council could maintain the plan, but it was not obliged to take the steps to secure the provision within it. And he says further at paragraph 245, I am satisfied that the 2014 Act permits a local authority in circumstances such as these to maintain the plan without breaching its statutory duty. And below that says, it seems to me that the reality is that no action would or could sensibly be taken by a child's parents against a local authority in circumstances such as these if it simply maintained the status quo. And the point we raise here is how does that sit with the understanding, which we say is is not in dispute, in relation to the operation of section 42 subsection 2 of the Children and Families Act, which on established principles is that the duty to secure is absolute, non-delegable, and does not permit a best endeavours defence or anything of that nature. You don't have the case law for that in the authorities bundle because those propositions are not in dispute, but I have referenced them on page 229 of the core bundle, footnote 6. So you have the relevant authorities there for your own research.
Yes.
As I say, these are not principles that are in dispute. We say that this does pose some practical questions which are of concern for local authorities in this area. The first is...
Well, sorry.
Yes.
I mean, you say we can look at them for our own research, but where would they take us? There's an absolute non-delegable duty to secure educational provision, not to provide it.
Well, to secure is the language, and that does mean that it must be provided and facilitated.
Well, in Lord Justice Stuart-Smith's example of a family where father or mother is deployed, whether by the Crown or by a private sector employer, to Dubai for a term.
Yes.
And I think you accepted that wouldn't remove Hampshire's responsibility to maintain a plan. But are they breaking the law if they don't provide the schooling in Dubai?
No, in that situation, because it's understood that following a temporary period of absence, the child's going to return to Hampshire and go to school. And
for an autistic child, a term is a long time.
For any child, a term it can be a long time, particularly if they have special educational needs. But the provision would be in place for the question that arises is, does the local authority have to continue that provision within the school that is specified in the EHC plan, which will in that case be the school in Hampshire, or does it have to make provision abroad? And that is something which we say is not answered by the First-tier Tribunal or Upper Tribunal Judge West, because what they effectively say is a local authority doesn't really need to concern itself about this because nobody's going to enforce against them. But it does give rise to practical considerations of difficulty where you have these situations of individuals moving abroad. And
But the answer, if someone were to raise it with the local authority, the conclusive answer would be it's out of our power.
Well, the answer in this case was that the child is outside of the area, and so we don't need to maintain the plan anymore. And that's how the local authority deals with the difficulties posed by Section 42.2.
Taking an example where it's accepted that the local authority is still liable to maintain an AHC plan under 42.1. There are two circumstances in which the local authority may be literally unable to discharge an obligation to secure the specified special educational provision. One is catered for by subsection 5,
Yes.
which says that does not apply if the child's parents had made suitable alternative. But if, for example, the parents took the child to Dubai and made no provision for the child's needs, I'm not quite sure who it might be, but someone might raise with the authority, you haven't secured the specified special educational provision for the child or young person. And what I was suggesting, and would be grateful for your assistance with, is would it not be a complete answer for the authority to say, that's right, but it's out of our power. And therefore, there is no point in trying to impose any sanction or making any order because the council literally cannot do anything about it.
I mean, if that's an interpretation of Section 42.2 that your lordships and ladyship are minded to endorse, then that would provide assistance to local authorities in cases like this. But that is not the effect. We would respectfully say of the Upper Tribunal's decision, which doesn't go that far. The decision and its effect leaves questions, and one of the reasons for this appeal is because it genuinely leaves practical questions in the authority's mind as to how its duty under Section 42.2 can be met. Of course, this is a case where the parents were saying that the local authority should continue to maintain the plan in their absence.
They should maintain the plan, but there's the difference.
But
Maintain the plan, but they were not suggesting, no one has suggested in this case that while the child was in Dubai, Hampshire should have been providing the specified educational provision.
And it's reconciling that with the absolute nature of Section 42, subsection 2, that is a difficulty, because Section 42 says, subsection 2 of Section 42 says when a plan is maintained,
but
there's a duty to
that's
secure
why
it.
I'm looking for your assistance, and if we can agree that 42.5 takes out a certain tranche of cases.
Yes.
But we needn't argue about whether this case is one of them. But
Right.
then you have a rump. You're going to have a rump where, because the child is in Dubai, it is simply not. I'm assuming that it is not in Hampshire's power to comply with subsection 2, which is the provision of the services.
Well, it's not able to for the reasons that your lordship summarises. The First-tier Tribunal, in this case, recognised that it would be impossible for the local authority to comply with Section 42.2, and we say that that's
So
position.
what's the legal route by which you end up with the Chief Executive of Hampshire County Council not being taken away in chains?
We would hope that would be an extreme eventuality, and then one wouldn't arise. But see, this my lords and my lady, is a situation where it's not clear is the reality. There could be an assurance, an express assurance, written assurance given by parents in such circumstances, but it's impossible to see that it could go further than that, because the strict nature of the duty is, and it's not in dispute between the parties, an absolute one. So a local authority finds itself in a difficult position where, even as a matter of...
Sorry, forgive me for interrupting.
My lord.
Absolute duty to maintain a plan, but not an absolute duty to provide schooling or provide anything else.
Well, if we turn to the language of Section 42, subsection 2, that's...
Page 23.
Grateful, my lord. the subsection 1 says this section applies where the local authority maintains the plan, so that's a distinct concept. The local authority under 2 must secure the specified special educational provision for the child or young person. So if it's maintaining the plan, then the duty kicks in to secure the provision. Securing the provision, in my submission, means that it is provided.
But it's going to be the same answer whether it's very short, 1 term, or a year, isn't it? It's going to be the response under 2 is going to be the same.
I think that is the reality of the duty, yes. If the provision bites, then the duty applies, whether that's for a week or a year.
So whether you do that by statutory interpretation and say this must mean to the extent that it's in their power, or whether you do it by some other means and just simply say it's absolutely absolute, but no one's going to enforce it because they can't.
Well, again, this is an area where the local authority would be grateful of your lordship's and ladyship's guidance on that, because at the moment the case law is to the extent that it's absolute, and if a local authority is placed in a position where it cannot comply, then it might be that in cases, and this may be one of those cases, that in reality a parent isn't going to seek to take enforcement steps, and a local authority will no doubt be grateful in those circumstances. But there might be other cases where that is not the case, where children and young people are abroad.
Who else might?
It's not inconceivable that that parents move to another country and require special educational provision to be made in that country.
What, by the local authority here?
Well, we say that that's not something that should arise, or can arise, but I'm suggesting that that is something that an individual who has the benefit of an EHC plan may wish to invoke of themselves. We don't think that in law they would have a basis, but that is a situation we could see arising.
I will flag that up as a question which Mr. Gilly will be asked to answer this afternoon. This family did not.
No, I accept that, and I accept that may be the mainstay of cases, but we do see there to be a tension with how the duty operates, and cases like this.
If we just come back to the,
yes, my lady,
if I can call it the routine case, the majority of cases. The majority of cases, local authorities are in contact with families in this, no doubt not as much as the social workers would choose because of resource constraints, but there is an involvement through the schools and through social services with these families who have special educational needs. So if the family are going to go to Dubai or wherever, whether as a serviceman or for other reasons, the reality is ordinarily there's going to be discussions as between whether it's the school and the family and the local authority, and there'll be discussions about how it's going to be made to work for the child, and so 9 times out of 10 when you're actually on the ground, surely the local authority are going to be saved by subsection 5.
So subsection 5, which is the alternative arrangements provision, I accept that where that applies.
But no, that wasn't my question. My question is, I just wanted to think, actually, when we're on the ground, let's just thinking about most cases. In most cases, your local authority that you're worried about breaching subsection 2 are going to be saved by subsection 5.
They could be. Whether it's most cases is not something I would be able to venture to say is right. What I do understand.
But have you been told about examples where parents have just sort of disappeared when they've got they've got educational provision and they've just disappeared and not told anyone? And
with the children.
There are in a lot of these cases, the local authority, like this case, doesn't become aware of that until after the event.
All right.
There are a number of cases where individuals are moving abroad permanently, and so therefore, if there is a cease to maintain decision,
but if they're moving permanently, then
the question doesn't.
The question
It's not a
doesn't
problem.
arise.
That's why I say the plan has ceased there's
Yeah.
a cease to maintain decision, and there's no dispute about that.
After suitable consultation.
Well, certainly the law says that that's what should happen in cases. I would accept that. But perhaps I won't go over old
No,
ground
don't
on
go.
that.
No. It was gratuitous on my part.
I'm grateful, my lord. The problem really arises, and howsoever you define it, I'm not attempting to do so, is in these cases of temporary absence. Yes, I accept the cases where I hypothesise where somebody wants provision abroad are going to be few and far between realistically. But the more pertinent scenario is when people are abroad for a period of time but want the provision in place in England, so it's there when they
come back.
return. And that does have practical consequences financially for the local authority. If you've got a child who is away for a period of years, that potentially means provision needs to be secured for them in that period. A lot of these are well, if you take, for example, a child who needs speech and language therapy.
Well, you're not going to block out chunks of the diary of the speech and language therapist and saying, can't use that because this child's abroad, and
I mean, a lot
so
of
we
these.
can't substitute it in. I mean, that would be a nonsense.
I mean, some of these contracts are blocked out, but it does.
But you give it to another child.
It does give rise to questions as to how that operates, and potentially if a school place is left open as well, whether that is taken by another individual. So I think these are.
So you're saying that the way that temporary removal works is that the school place is not filled, speech language therapist place is not filled, and you just have gaps. No other child's allowed to take the benefit of those.
Well, if there's an EHC plan which specifies the school and the provision, the practical reality is that is not something a local authority would wish to do, which is why we do not wish to maintain plans in circumstances of long-term absence. When a child or young person presents themselves in the area following such a period, then of course they are in the area for Section 24 purposes, and the assessment duties.
And they then have to wait 10, 12, 16 months before they're assessed.
There are mitigations for that for service families that arise through the Armed Service Covenant and statutory responsibilities under the 2006 Armed Forces Act, which Judge West refers to in his judgment. And also, as in this case, which is something that a local authority can, of course, do pursuant to those matters, it can provide, well, it can seek to expedite those processes, and it can provide interim funding so that even without an EHC plan, there is funding in place for special educational provision pending the outcome of the assessment, and that's what this local authority offered.
Oh, I understand that. Obviously
Yes.
on the facts of this case, this local authority acted in a very principled way. I mean, obviously.
But my lady, that we say that is something which local authorities faced with service cases will and should look to do because of obligations arising from, for example, under the covenant. The other practical question is annual review, because the lifespan of an EHC plan is a year, subject to annual review, and that is an important statutory function for several reasons, including that it gives rise to an appeal afterwards. But the main purpose of it is practical to ensure that needs and provision are current, but that is a much more difficult task to perform if a child is abroad, and if you simply maintain a plan, but your position is you don't have to secure the provision in it. The reality is that that plan remains potentially as it is for a lengthy period of time, and is a relatively stale document by the time the individual comes back anyway,
Well,
which
what's wrong-
then requires
what-
an assessment.
What's wrong with that? I mean, suppose
Yes.
that Mr. Gilly is right in principle that T remained, quote, in the area while in Dubai, so that the duty to maintain the EHC plan continued.
Yes.
But what would be wrong with, in year one, saying the plan for the year ahead is that he's going to school in Dubai, the parents have made those arrangements, and they'll let us know if that changes, and 12 months later the parents report we're now into year 2 of the secondment. He's still at school. There's nothing else you need to do at the moment. We expect to return in July, whatever it is, at the end of year 3, and so on. What's wrong with that?
Well, the problem arises if there's uncertainty about what is happening from a practical and funding perspective in the meantime, but I've addressed that. If I would say that actually, on my proposal, which is a local authority is entitled to cease to maintain and then commence the process again when the child returns, the child is in no real different situation, particularly in this case, when the processes are expedited and funding is provided, so that special educational provision is there when they do return. I think the difficulty from our perspective with the what's wrong question in the meantime is properly understanding what the extent of the local authority's duties are in that period, which is a distinct question from, well, in reality, is this particular family going to seek to enforce any of those duties?
Given that your local authority, your instructions are that there's certain circumstances on using your presence criteria where, notwithstanding a child was temporarily somewhere else, for a month, whatever, a term or whatever it is, wouldn't a lot of this be resolved if the focus was on what's going to amount as temporary? Because if the focus, because when I was reading this, I kept thinking, but doesn't this all turn on what is temporary? Because if the local authority, and I can see that could be a matter of dispute, and that would be resolved in the normal way. But, you know, if you are going away for 6 months, and the absolute circumstances is a fixed term contract, they've let out their house, or the service person is on secondment for however long, and they've kept their home base, whatever, and they'd regard that as temporary. But if someone's sort of drifting off, well, I'm going to Australia for a year, and I'm just going to see how it goes, the local authority could say, well, absolutely not, that is not temporary, and therefore I'll be ceasing to provide that. It just seemed to me that a lot of these very difficult questions could be answered. We moved away from a lot of all this stuff, and the focus was on what's temporary.
I agree, and I think there's a natural relationship consequentially between grounds 2 and ground 3. I mean, in this, and I would accept that, and that's one of the reasons why I've apportioned less time to it. I think in this local authority's case, the decision was that this wasn't materially temporary, such that it was permanent, and they ceased to maintain, and that is the decision that they made. The question that arises out of that decision because of the appeal is, well, what are the legal consequences in light of the tribunal's finding that we were wrong to do that? But the starting point I would accept is as per ground 2, the issue about in the area and how that is to be construed.
Right. What any topics or subtopics that you have not yet covered? Would you like to have a word with Ms. Buffet?
Yes, I will. Before I do, I haven't said much other than in passing about section 42.5, and your lordship indicated that's not something I need to go into in a great deal of detail, but I have referred to it in the skeleton argument, and I simply draw to your lordship's attention the White and Ealing case. You have the reference in the skeleton argument.
Where is that?
Ms. Buffet will perhaps assist me with that whilst I look. At the end somewhere. Page. I've got it. Yeah. Thanks. So page 247 and footnote 43
of the authorities manual.
No, that's
Are you
in
in?
the
Where
full-
are you?
That's in the full bundle. I can give you the passage in the authorities bundle as well, so you can get straight to it. It starts at page 150. Grateful. I'm grateful to Mr. Gilly, who says it's 170, and I'm sure he's right.
150 is the start. Yes,
150 is the first page
Yeah,
of the
thank
authority. 170 through to 171. It's actually the paragraph at the bottom of 170 going into 171. And that is just to support the point that we say for that provision to be engaged, it requires a decision, which is a decision that is evaluative by a local authority. And in this case, there was no such decision, but the alternative arrangements were suitable. And so that provision isn't engaged in this case. I'm just going to check for a moment, if I may, to see if there's anything else. Sorry, was it something else? Yeah. That was referred to in Kent, wasn't it? Yeah. I'm grateful to Ms. Buffet. The only points arising are in my submissions about the G and Kent case. My lady, you referred to an authority that's referred to in that, and you asked, is it in the authorities bundle? And I said it isn't. Would you like us to get?
Well, I was just going to go on to ELIS over the short adjournment. Thank you. I've made the reference I've just jotted down in my margin is 2015 UK Supreme Court 46, and the relevant paragraphs 42.
That's great.
Yeah, got to guess one. I'm very happy to look at that over the short adjournment, but thank you very much. It's very helpful.
It was a similar question, my lord, in relation to an earlier judgment. I think you referred to the judge, but not the case title. We can do our best on that to find it. Can we assist your lordship in any way with that further? I think it was all Justice Etherington.
The case following Sonagia.
Yeah.
I'll have it by the end of lunch.
We'll do our best. I referred to the A1 properties case. That's not in the bundle. Do you need to see it?
I should be able to find it because I think I cited it at all about 6 weeks ago.
Your lordship is better
But
placed
that's
than I am sure. We'll do our best. All right. Well, unless there's anything else that I can assist the court with, those are submissions. I've obviously set it out in the skeleton argument as well.
Have
relying
indeed.
to set
Yes.
that.
Thank you.
Ms. Buffet,
No, thank you.
thank you very much.
Thank you, my lords. Thank you, my lady.
2 o'clock.
Court rise, please.